and the honorable learned members of the court. I am Gitu Muigai'S, and I appear for the IEBC for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub Guley and Boya Molu. I am assisted in the defense of this gentleman and the institution by Kamau Karori, Senior Counsel, Abdikadir Hussein Mohammed, Senior Counsel, Mr. Eric Gumbo, Mr. Mahat Somane, Dr. Willie Mutumbwa, and Mr. Peter Wanyama. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours, plus the 1 hour between the 2 commissioners who are represented by our team.
That is not correct, Prof. The 2 commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They had 1 hour among the 4 of them. So you have 3.5 hours. I'm
guided by you, my lady, and I have changed that to 3.5 hours. Thank you. We have filed before you a wide range of documentation, which in our very humble view is very, very comprehensive. We draw your attention, honorable members of the court, the responses on behalf of the chairperson and IEBC, the affidavit of Wafula Chebukati, the affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Guley, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Uma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director of voter registration, and affidavits filed by presiding officers and residing officers of the contested polling stations and constituencies. Let me start, my lady Chief Justice, by observing the peculiar nature of the proceedings before this court. That is to say, these are proceedings that are based on affidavit evidence. And we all appreciate the limitations that has. That we have persons who have sworn affidavits who are not available to court to be cross-examined on their allegations. And some of the allegations we have had, as we shall demonstrate in the course of our submissions, are outrageous, to say the least. My lords and ladies, we have been here before you. Some of us have had the great privilege of being here before you in 2013, in 2017, twice. And this honorable court must take credit, I think, unparalleled in anywhere in the Commonwealth, in my humble learning of the subject, in helping to clarify how the electoral process in Kenya should be conducted. And we submit that the clarifications that this court has given since 2013 have enriched the conduct of the electoral process. And it is my first submission that the IEBC and its chairman conducted the 9th August 2022 presidential elections strictly in compliance with the guidelines that this court has given. My lords, since the annulment of the presidential election in 2017, IEBC overhauled its entire electoral process procedures to align those procedures with the guidelines that my lords had given. Your decision in the minor care, the decision of the Court of Appeal in the minor care case set out the guidelines for the protection of the ballot at the polling station, the transmission, tallying, and declaration of presidential results. We have abided by that decision. Your decision, my lords, in Raila Odinga versus IEBC petition number 1 of 2017 rendered even more detailed clarifications on the procedure. The decision in the National Super Alliance versus the Independent Commission gave further clarification as to the very controversial issue up to that time of how to handle complementary voting. And again, we learned from that, and we have used that in this election. Since 2017, over the last 5 years, the IEBC undertook post-election evaluation. It reviewed its strategic plan. It developed an elections operations plan, a boundaries review operations plan, continuous registration of voters, and several other measures that flowed from the guidance that this court had given. My ladies and my lords, in the cases that have brought us before you previously, we had numerous arguments about jurisprudence. What does the law mean? What do the regulations mean? What does the Act say? The petition now before you has absolutely nothing to do with any legal lacuna, because you have spoken so loudly on that subject previously. Although my learned friend, Mr. Karori, will be reiterating what you have said as regards Article 183, your own thoughts on the subject are very well laid out in your previous judgment. This, my lord, is a petition about facts. It's a petition about what happened. What happened, when, where, with what consequences. And therefore, ultimately, notwithstanding the very lucid and learned and honest arguments by my very learned friends to my right, this petition is about numbers. It is ultimately about numbers. The petitioners have tried to argue every other point except numbers. I will be demonstrating to you, my lady. My learned friend, Mr. Kamau Karori, will follow me, and he will get back to the parameters that you have set. Mr. Eric Gumbo will talk about, that's Mr. Karori will answer, and this is very important, my lords. We do not want to waste our 3 hours perambulating around every conceivable issue in this petition. We will be answering the questions you asked us. Mr. Kamau Karori will answer question 4, 6, and 8. And that will be a submission about the electoral process. My learned colleague, Eric Gumbo, will answer question 1, 2, and 3, and that's about the technology. My learned friend, Mr. Mahat Somane, will answer question 4, 3, 4, 5, 7, and 8. And I do not want to belittle the rest of our effort, but that is the man who will explain that numbers don't lie. that numbers speak for themselves. Mr. Abdikadir Mohammed, Senior Counsel, will address you on the burden of proof and the standard of proof and whether the reliefs sought by the petitioners can be granted in this matter. If we still have time, as we hope we shall, Dr. Mutumbwa and Peter Wanyama will address you on this issue that seems to be in the fridges, but in our view, totally inconsequential, of the KPMG report and the alleged problems with the voter registrar. Let me start by saying, my lords, you have been urged by several counsel who have spoken before me to find that this election was irretrievably flawed. That from the word go, one counsel said, and I quote, everything that could go wrong went wrong. If that be true, and we deny that that is true, then it would mean that everything from voter registration, voter education, procurement, nomination, voting, counting, tallying, verification, and declaration was totally flawed. What would be the consequence of that? First of all, and I say this with the most tremendous respect, first of all, you have been addressed by counsel of great eminence, including my learned senior James Orengo, my learned junior Professor Tom Ojenda. In this court, my lords, as we sit here this morning, there are no less than 3 governors addressing you elected under this election. There are no less than 4 senators elected under this election. And there are no less than 4 members of parliament elected under this election. When, my lords, it is not in my place to suggest the questions you should put to counsel, but I would plead with you to put that question to counsel when they return to the podium. Are they happy with their own election? If they are, how then is it that this election is irredeemably flawed? I suggest with tremendous respect that that is the use of hyperbole. This election was conducted as most international observers observed. It was the fairest. All observers came back with one conclusion. This was an open, transparent election. Was it a perfect election? No, because there is nothing like a perfect election. This is an election conducted by human beings, and there are human errors within the electoral process. Were the few errors that are admitted by IEBC of a magnitude to allow this court to set aside the election? It is our humble submission that the answer is no. It has not been demonstrated, and my learned friend, Mr. Abdikadir, will deal with that matter. Let me point out to you, my lords, that this is one of the few petitions that this court has seen that is full of generalities, innuendos, hypothecations. Yeah. We believe there was one counsel who repeated several times, our theory is, our take is, our understanding is, not evidence, nothing of probative value, speculation, generalization. It is our very humble submission that, framed in those general speculative terms, lacking clear, cogent, probable evidence, these petitions lack merit. It is made worse, my ladies and my lords, by the fact that the petitions make grave allegations of a criminal nature: fraud, tampering with election materials and results, conspiracy to unlawfully influence an election outcome, and even implied treason. Implied treason. All that without a shred of evidence. All that without a shred of evidence, especially as it relates to the Honorable Chebukati, the chairman of the commission. The vilification against this gentleman goes beyond anything we have ever had before in this courthouse. It was personalized, it was vindictive, it intended to lower his standing in our community and within the legal profession. It was unwarranted. I have had occasion again to defend Mr. Chebukati, although he was not my client. I was in a different office. But I recall mentioning in 2017 before your lordships that this gentleman was being vilified for doing exactly what the minor Kiai court told him to do. It told him, don't touch the results coming out of the polling station. That is the final result. We then came here to this court and he was called all manner of names at that time. This has not stopped. What should we learn from this? We should learn one thing, and it is a very unhappy lesson. The attack on the chairpersons of the commission has a long history. There was Justice Zacchaeus Chesoni, there was Samuel Kivuitu, there was Isaac Hassan, and now there is Chebukati. The pattern is the same. The pattern is the same. None of them has been allowed to leave office without vilification and a vindictive process being engineered against them. I don't want to go to the details because we all know the details. We remember the details. So what is wrong? There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem. At an appropriate time, when all this is over, I entertain no doubt that an independent group of people looking at the work that Mr. Wafula Chebukati has done for our nation will recognize him as one of our outstanding heroes in the history of our nation. Thirdly, I want to say that the evidentiary material, which will be addressed by my colleagues, is of such a character that it falls way below the standard you set in petition number 1 of 2017. And since I don't want to take too much time, I'll leave that for that purpose. To return to this issue, that this court, in our very humble view, needs and I am very sure from the questions the court has asked so far, that the court appreciates very deeply in that any order has consequences, and those consequences must be consequences that can be contained in our democratic and constitutional process. The Supreme Court cannot act in vain. It cannot act so as that the judgment should read like a learned legal article. The Supreme Court always acts so that it can defend democracy and the rule of law and constitutionalism in a practical and enforceable way. So if this election is so badly flawed as you are invited to find, then this court would have to find that every MCA, every MP, and every senator and every governor was not properly elected, and the whole of the government of the Republic of Kenya should be reconstituted afresh. I don't know whether my learned colleagues have contemplated the consequence of what they have requested. My client, Mr. Wafula Chebukati, is a man who enjoys constitutional protection of his tenure. Why did the Constitution protect him? Not him alone, the chairman of independent commissions, for precisely this form of witch hunting. The Constitution cannot countenance that a constitutional office holder is to be witch hunted in the manner suggested here. That he walked out of his office and took the phone many times, then came down and sat down and did not consult the people who were having tea. A whole lot of irrelevant material that cannot be the basis of interfering with the independence in section 163 of Mr. Wafula Chebukati. It is said that he should be removed from office and forbidden from ever holding public office. And I want to ask my learned colleagues for the petitioners, is that really a serious submission? When the Constitution itself contains complex processes of the removal of a person, he is now to be removed here by reference to affidavits of hearsay on the back of hearsay? I do not think it is a serious submission, and I invite my lords not to act on it at all. Two final points before I invite my learned colleagues. My very able senior learned friend, Paul Muigai'S, said that the commission is the majority of the commissioners. That cannot be a meaning of the commission that arises from the Constitution. The Constitution contemplates that the word commission will be used in multiple senses. The returning officer, when he makes a declaration, is the commission. The officers of the commission, when they procure, let us take procurement. When the procurement process is done by officers of the commission, that is the commission. When the chairman declares the presidential vote, he is the commission. There are multiple senses in which the Constitution uses the commission. It does not intend that the commission is to be used as sitting in plenary and voting, because very little of the commission's work involves voting. I believe that if we cure that misunderstanding of the commission, the rest will follow. It will be quite clear that Wafula Chebukati was acting as the commission in the manner defined by the Constitution at that point. Because it is a body corporate, and that has already been spoken to. Let us come to this last point about how did the commission break apart? Again, I don't want to belabor this point because the learned court itself has raised this issue. We have an election conducted up to the 11th and a half hour, and everybody is on board. Everybody is on board. The public can see them declaring the results. What is this that happens within the half hour? The affidavits speak for itself, for themselves rather. And my learned colleague will take you into the detail. The affidavit speaks to themselves. There is a concerted effort. There is a concerted effort, external, to ensure that the process comes to an end without a declaration. So the sanctimonious, self-righteous, pompous pontification of the so-called 4 commissioners are an afterthought. They are a complete and total afterthought. And should be seen as that. One shudders to contemplate what would have happened constitutionally. So there is no, the election is not called. The deadline is the following day. It is not called. We then go into an uncharted waters. Totally uncharted waters. We have a caretaker government in place that is hamstrung in what it can do. We cannot set up a new government because an election was not declared. We cannot call a fresh election. I shudder to think what would have happened. I'm sure the court would share the same concern. And I want to say this before I sit down, my ladies and my lords. Integrity is not numbers. Integrity is not numbers. And that's why the great statesman said, I protest. I protest even if I do so alone. To do the right thing does not require you to be with the majority. It requires you to be with your conscience. I invite Mr. Kamau Karoli to address you on the issue of 183, and I thank you.
Senior Counsel, before maybe you see it, we have received information that your side is going to present 2 videos and a PowerPoint presentation. The first video will take 4 minutes, the second video 14 seconds, and the PowerPoint presentation, which has 28 slides. We don't know how long it will take, but just to warn you that that is within your time.
Most obliged.
Your time will be taken into consideration. We will not lose time like we did yesterday. We are very keen.
Most obliged, my lady.
May I please, my lady, the Chief Justice and judges of this court, and good morning. My lady and my lords, I will be